My name's Alistair Edwards. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, and I've been appointed by Scottish ministers to hold the inquiry overall and thereafter report to them with a recommendation on whether to approve or refuse this application. Now, housekeeping arrangements are the same as they were for the past 2 days, so please be aware of any fire evacuation processes that are in the building that you're in for today. When you're using the microphones, if you can just remember to turn them on when you're speaking and turn them off when you're not, and raise your hand either physically or by using the raise hand button if you have a point to make. If you can remember that this session is being broadcast live and filmed. Now, there's one procedural matter before we continue with the hearing session today, and that's to do with the Crossdykes Wind Farm and the arrangements for that and closing submissions. So I've had a brief look at that, and I've got a suggested range of dates for parties if you'd like to hear that.
Yes, yes, indeed. Thank you.
Yeah. So if I did further written submissions just on the matter of Crossdykes Wind Farm and Aviation Monday, so that would be the 27th of January to the 10th of February for that procedure. And then a 7-day rebuttal period to the 17th of February. Then the closing submissions from yourself, Mr. O'Carroll, on the 24th of February. With the applicant coming in with their closing submissions on the 10th of March. Does that sound agreeable? I realize I've just thrown those dates at you.
Yes, we've got no objection at all. Thank you.
Okay, Mr. O'Carroll?
So the date for closing submissions will be moved from the 7th of February to the 24th of February.
For yourself, yes.
Yes, thank you. That would be fine. Thank you. I've been giving some thought to this, and yeah, I'll just leave it at that. Thank you. That's very helpful. Thank you very much.
Okay, and just Mr. Hardy, have we got confirmation yet whether or not the lights at Crossdykes are working?
So yes, we took instructions. Yes, they are. In short, there is a question mark over. So there are 5 lights. When you are at a place called Corrie Common, there is a question mark over the light to the left, which I'm just trying to sort out. I understand they are all working. 4 of them definitely are. There's a question mark over the one to the left, which we're just trying to sort out this morning. But you can definitely see 4 working according to spec and in compliance with the scheme. What I'm hoping to do is, and I can outside of the inquiry, can share this with the council, give some suggested places to see Crossdykes, some agreed positions. There's a couple of viewpoints, and that is a relatively straightforward exercise, given that the nighttime effect from Wind Farm was under discussion at the inquiry just before Christmas, but as part of that, Crossdykes was the comparator, so there were some nighttime viewpoints agreed with the council. They were thought to be the best, and I would hope that they can be agreed with the council this time around as being suitable to see Crossdykes.
Okay, that would be helpful. I think what I'll do is I'll inform parties when I'm planning to do the inspection, just to check that conditions are correct and the lights are all working correctly. And that's the wind farm near Langham, is that correct?
Correct, yes.
On that, it seems to me that it, just as in the case of Strathoical, which I referred to in evidence, that was an unaccompanied site inspection. And it seems to me that it would be perhaps fortunate for that also to be an unaccompanied site inspection for Crossdykes.
Yes, we're content with that.
With regard to closing further written submissions in relation to that on the 27th of January, that would be for me then to, on behalf of the council, to provide something essentially to be written tomorrow for submission by close of play on Monday. I'm not sure if there's very much for me to say, and I say that for this reason, is that the position is of the applicant that the situation there is comparable to the position that will be arising in relation to the current development. Unlike unlike the other one at Long Hill Burn, which is not functioning. That being the case, then that's clearly the submission. That's the submission on the part of the applicant, and that's the assurance that they're giving. I noticed from the suggested change in condition that's just been circulated just today, I can see that the proposed change 14 paragraph 3A says that the specification of the model of aviation light proposed to be installed will be provided. So the only thing that I think really requires to be clarified, and coming from the applicant rather than anything that the council can add, because we're kind of behind here because we don't know what the applicants know. But the only thing that seems to me that is required is for the applicant to say that they consider that the lighting situation at Cross Dykes is the same as would be visible from the proposed scheme at Breackerie. And there might be a difficulty with that given the uncertainty regarding the actual model used, and also given that the wording of the new proposed condition. So it seems difficult for them to then provide that complete assurance with regard to the lighting model that will be used for that. And so given that, there's very little else for me to really add, because there is that uncertainty. But if that certainty were provided, and if the comparison was the tribunal, the inquiry was assured of that valid comparison, then I don't really think there's any need for the council to provide any further submissions on that, because you've heard the council's position from the words of Mr. Daly yesterday about uncertainty, and in terms of submissions from myself. So I'm not sure if further submissions from me by 27th of January is going to add very much to that.
Okay, I mean, the further written submissions would begin on the 27th of January, but you'd have until the 10th of February to make a submission.
Okay.
Yeah, so I would issue a further written submission procedure notice on the 27th, allowing parties 2 weeks. I was under the impression that perhaps Mr. Daly might update his position in terms of his inquiry report in that period, in reference to Cross Dykes rather than Long Hill Burn.
I think that might be disproportionate, because that would involve him going out to Dumfries and Galloway and to carry out the similar exercise that he carried out in respect of Long Hill Burn in West Lothian. And I think in light of the evidence that was led yesterday, I think it'd be disproportionate to reinvent that particular part of the wheel. And I think matters could be truncated in the manner I've suggested, that we get the necessary assurance from the applicant, and that can then form part of the submissions, in closing submissions taken all together with regard to all visual effects. I hope that would be a shorter, neater, more expeditious way of dealing with matters.
Mr. Hardy, any thoughts? Yes, I mean, I hear what Mr. O'Carroll's got to say. It isn't possible to say that it's exactly the same, because the lighting specifications may be different, the light that may be purchased from for this scheme. However, what we can say, what we are saying, is that the Cross Dykes Wind Farm is operating in accordance with its specification and pursuant to the agreed lighting scheme. So within its own terms of reference, that is a wind farm that we are saying is operating, and that is operating in the reduced mode, which is in terms of its luminance the same as that which would prevail in this scheme. So I can't go so far as to saying it's going to be the same light, but I don't think that's necessary, given the comparison that you are seeking to draw. What the condition does, and I don't know whether you've seen that this morning, sir, but it was a revised aviation lighting condition. It's certainly gone to the council. I'm not entirely sure that it's gone to you, but we'll get to that this afternoon. That has got 3 parts to it. as suggested. That is that there is a suspensive element for agreement of the light. There is a compliance part of that, so testing, and then there is a mitigation part if the check demonstrates that it's out of accord with the with what it should be doing. So that's what we are proposing in light of the conversations. So the final, apparently, I've just been told by Mr. Campbell, it has been sent to the DPA case officer with a request to pass it on to you as soon as possible. So final choice would be for the council, but what I can say in terms of luminance, that is going to be the same, and I can say that Cross Dykes, so far as we're aware, is operating according to its spec. Whether or not that means that there've got to be further submissions from the council, it may be. That gives you the comfort, Mr. O'Carroll, that you need to say, well, we can't really say much else. It's a matter for the reporter to go and have a look and see what a 200, candela light looks like, in the field.
Well, that's exactly it. Thank you very much, Mr. Hardy. I think that's extremely helpful. So if there are further written submissions coming from the 27th of January setting out what Mr. Hardy's just said, it may well be that there will be a little or no response required from the council, but we shall see with that. But I do appreciate the consideration that's been allowed for that. Thank you.
What I can also do, and I will do this, Mr. O'Carroll, with your team, make sure that we give you the viewpoints, we'll give you the reports which indicate why those viewpoints are chosen and the sort of evidence that was put in at Scoop. It will be available on the website, but we can just direct you to a few key documents that I think will help.
Thank you.
Okay, so we'll proceed on that basis. I'll still issue a further written submission. I'll tighten that up now based on the discussion that we've just had, but we'll stick with those revised dates if that's still okay with parties. So Mr. O'Carroll, your closing submissions now be February 24th.
Thank you.
I mean, there's absolutely no reason as well that you can't submit those earlier. And that's the same for yourself, Mr. Hardy. So it'd be the 10th of March. But again, if you submit them earlier, it's only going to help me in writing up my decision. Thank you. So, are there any other procedural matters before we move on to today's hearing?
Thank you. No, nothing from me, so thank you.
Okay. So today we're moving on to our hearing session on planning and energy policy. As parties are aware, and for those viewing proceedings, hearings are a less formal procedure where I will lead the discussion based on the agendas for each of the sessions that have already been circulated. So obviously we have a conditions hearing session later today. In effect, we'll proceed through the agenda items and I'll direct questions to witnesses that in turn can initiate a discussion on that matter until I consider that I have sufficient information. Now, are there any questions about that process? Okay, could I ask each of the parties to introduce themselves? So I'll begin with yourself, Mr. Hardy.
Yes, so if anyone's listening, so David Hardy, duly qualified barrister, solicitor partner at CMS. And for this session, it's going to be principally led by Mr. David Bell, who is sitting, just to be clear, is in our offices, but this is a hearing rather than inquiry. So he's to my right. We also then have Mr. Keith Campbell. We've got Mr. Gordon, and then we've got Mr. Potter. And we also have you on the call. We have two members of the two representatives from the client with me as well.
Thank you. Mr. O'Carroll?
Maurice O'Carroll for Argyll and Bute Council. I'm an advocate in Scotland, barrister in England and Wales, representing them today. I have also with me Mr. Ian Kelly, who will be the principal witness at this hearing session. But also on the call we have Shelley Gould, who is an officer with client Argyll and Bute Council. Not my understanding that she'll be contributing to this particular session, although of course she's welcome to do so. But that she'll be primarily listening into this, so that she will be contributing at this afternoon session on conditions.
Okay, thank you very much, everyone. Well, we've moved through item 1. We've already agreed at the pre-examination meeting to use the code of practice for handling inquiries. So I don't think, unless there's any points that anybody has under item 2, we can move on to item 3. Now, you'll see from the agenda that I've set out headings, but also very specific questions. So my plan is to go through those specific questions, and then if there's any other matter under that heading that you'd like to raise, we can bring that up. And indeed, being a hearing, it's discursive. So if there's anything else that you'd like to raise or bring up, then please do as we go through today. So the first question is fairly straightforward. I've looked at the statement of agreed matters, and I've noted that the council hasn't agreed to several of the documents or the content of them being of relevant consideration. So could I ask the council why that is the case? You don't necessarily have to go through every document, but just in the round.
Thank you, sir. Your recent agenda has a series of very precise questions, which I very much welcome. It's my intention to try and give you very precise answers to those questions. It's certainly not my intention to read out anything that you already have in front of you, either from myself or from anybody else. In that way, I hope we can go quite quickly through the agenda. In relation to 3A, my position is that these are various background documents or papers that provide high-level input to the development of policy and guidance. They do not contain any guidance or criteria that help you make a locational decision for a specific project. And in that regard, notwithstanding all of these background papers, I note that in recent ministerial wind farm decisions, they still refer to their key consideration of the right development in the right place. So I don't, you're making a locational decision, and whilst these are relevant and important background papers, they are not specifically relevant to the recommendation that you have to make. Thank you, sir.
Thank you, Mr. Kelly. Mr. Bell, do you have any comment before I move on?
Thank you, sir. Good morning. Yes, just a few points. I think my first point would be, I think it's extremely surprising that Argyll and Bute Council is refusing to agree these not just background papers, it's legislation and statute as being relevant to the proposed development. It's the first time I've seen a council take such an extreme position, if I can put it that way, and we'll perhaps come on to some other points that stem from this stance. I think the key point I would make is that, just taking as one example, the sixth carbon budget is a fundamental document that has informed UK and Scottish government legislative provisions in terms of net zero. And we have the Scottish government's green industrial strategy at the other end of the list, which is clearly important in terms of what the government sees the role of renewable energy in the wider energy transition in terms of economic benefit, for example. So I won't say any more than that, just that the applicant's position is that these are relevant considerations for the consideration of the Section 36 application. Thank you.
Further, Mr. Kelly.
Yes, so Mr. Bell's just confirmed my position exactly. They are general background documents dealing with high-level issues. They are not specific to a specific locational decision on a specific project. Thank you, sir.
This is an iterative discussion, so if you want to come back in again, Mr. Bell, please do.
No, I think once we go through the agenda, sir, there'll be other points that we can expand on to further illuminate the respective positions on these documents. Thanks.
Thank you. So we'll move on to B. Mr. Kelly, what's the council's stance on the Climate Change Emissions Reduction Target Scotland Act 2024? Because there's no entry in the agreed statement for that.
I have no instructions in that matter.
If I could just venture my own observations then in that case, is that we have the position about the 2024 Act is that the main change is contained within Section 2 of that, and the fundamental change, which of course hit the press, was the replacement of annual and interim targets with budget targets, in contrast to the approach taken under the 2009 to 2019 Acts. The core document that covers that Act at core document 15013 that's been produced omits the explanatory notes that go with that legislation, and I would suggest that it might be helpful for you to look at that if you wish, because it is quite illustrative of what the real import of the changes are. I suppose the main point, and the one that the applicants no doubt will emphasise, is that the overall target for net zero by 2045 remains unchanged. But there is a subtle difference in matters. Section 44 remains, and that's the duty on authorities to act in a way conducive to contribute to the delivery of targets. But we have now a slightly new concept in that we don't have statutorily binding obligations or particular reductions by particular dates, but rather there is an obligation to look at the budget, and if the budget's not met, carbon reduction budget, then there has to be an explanation to Parliament. I suppose, though, that at the end of the day, the council stance is that it's neutral. Obviously, it's legislation, and we have it. I don't think it could be said that it diminishes the overall aim, which is carbon reduction, but the method of doing it is different. And really, I have nothing further to add beyond that.
Thank you, Mr. Carroll. Any comments from anybody on that particular point?
So yes, the applicant just make some comments. I think that's fair summary, and I think Mr. O'Carroll's final point that that binding legal obligation of net zero remains. I think it's important to note why this change to the 2019 Act took place. And in my hearing statement at paragraph 2.4.13, I refer to the Climate Change Committee's report to the Scottish Parliament, that's CD 12.016. And I don't think we need to go to it, but I have pulled out a quotation from that report where the Climate Change Committee has said it no longer believes, this is back in March last year, that the Scottish Government will meet its 2030 goal to reduce emissions by 75%. Now, the key point is that I would say not only is that commitment to net zero by 2045 still there, but Scotland has clearly been falling short of what had been aspired to. And there's clearly a bigger shortfall now than we expected, or the government expected to have by now. And that underlines the importance of going further and faster than before. And when we come to look at, for example, the Clean Power Action Plan that's been issued by the Scottish Government, again on the advice of the CCC, Climate Change Committee, it's very much about making up that ground. And although Mr. O'Carroll's right that there is not in Scotland a statutory emission target date for 2030, 2030 is still extremely important as set out in that 2030 action plan, which we have before the inquiry. Thank you.
Okay, is there anything else, or we move on to C? Okay, so you'll see that there's a climate change emergency that's been announced by both the Council and the Scottish Government in 2019-2021. What does that mean exactly for this application? Mr. Bell.
Thanks, sir. I think the declaration of the climate emergency underlines the seriousness of the issue of climate change and the need for taking action to tackle it. So there's urgency and there's delivery that comes from that. So I would say it's more than a declaration of that seriousness. It's a matter that is then expressly incorporated in policy documents. So just to give you two examples, the onshore wind policy statement, which is for the inquiry, that's CD reference 12.013, refers to the climate emergency, I think in the very first line of the document on page 3. The world is facing a climate emergency, and it goes on to refer to the action that Scotland will be taking on that. Secondly, in National Planning Framework 4, NPF 4, there is express reference to the climate emergency, for example, pages 3, 6, and 8, and also referenced within Policy 1 of NPF 4, which we may come on to. And that tells us that for projects that contribute to tackling the climate emergency, then significant weight should be afforded to them. So I think, moving from some of the documents we referred to in the first item, we get down to some specific land use planning documents that directly reference the climate emergency. And then there are policies and other actions that flow from that will be relevant. Thank you.
Kelly, do you have any response to that?
Yes, so the position is very simple. Nothing we do in Scotland will affect global climate. This wind farm will have no effect whatsoever on global climate patterns. Scotland only issues 0.1% of global emissions. And therefore, whilst recognising that climate change is a serious issue, my position is that as per local actions by the Council, the response should be matters that are effective in terms of addressing the effects of climate change in Scotland. Bearing in mind that the Oxford Dictionary defines an emergency as a sudden, serious and dangerous event or situation that needs immediate action to deal with it. And even if you disbelieve me in terms of the effects on global climate, consenting wind farms which may not be operational for, say, between 5 and 10 years from now is not, in my view, an immediate reaction. I get the sense there's a bit of politics in all of this in terms of political sound bites, whereas the reality is that there are issues in Scotland that arise from climate change that require to be addressed. And in fairness to NPF 4, there are many other parts of NPF 4, for example, in relation to 20-minute neighbourhoods, in relation to sustainable living, in relation to the circular economy, which are properly trying to make our living more sustainable in the face of climate change. But consenting and building wind farms will not have an effect on global climate.
Come to yourself in a second, Mr. Bell. Sorry, Mr. Kelly, you gave me a figure there for Scotland only issues something emissions on a global scale. Could you give me that one again?
0.1%.
Sorry.
And of course, if you've been reading any of the recent blogs and press coverage, you will see that at a global scale, emissions continue to increase, not decrease.
And so just for myself, the 0.1 emissions, is there a citation for that?
It's generally covered off in the technical press. The UK's contribution to global emissions is 1% of global emissions, and therefore, generally speaking, Scotland would be about a tenth of that.
Just before Mr. Kelly is, just before Mr. Bell is asked to respond to that, the question, sir, also asks about the statement of declaration from Argyll and Bute Council. And I think maybe just if I could just add a short word about that, and then Mr. Bell, if he wishes, could respond to everything together. I think might be more helpful. The climate emergency was indeed declared by the Council in 2021. And I think the position with regard to that is that it's simply a recognition by the Council that the impact that climate change is having around the world, and that it's a statement of its own commitment to respond effectively to it. What I'd say against that broad statement of intention is that it's also the case that as a local authority, it must do so and contribute towards that required aim in a manner that is responsible and not at any cost to the wider environment, which we're of course concerned with in an application such as this. The other thing is that I'd also mention is that the 2021 climate emergency declaration is now perhaps has been superseded to a fair degree, because looking at that, it was in 2021 at the time of which we had the 2019 legislation in place, and it was noted that there was 64.22% of time remaining to make up the 2030 target, which is set out in legislation. Of course, as we've just discussed, we now have carbon budgets, which is a different approach in light of matters that Mr. Bell has spoken about already. But it doesn't follow that anything that's said by the Council in relation to global climate change emergency doesn't mean that there should be any additional weight that are attached to proposals, and that formal policy, national policy or legislation are what they are, and the consideration remains the same, taken in the round with all the information that you have. In other words, the Council statement of climate emergency doesn't alter the weight that should be given to planning policy and energy policy that you must consider. Thank you. That's my answer to that.
Thank you, Mr. O'Carroll. Mr. Bell.
Thanks, sir. I know Mr. O'Carroll has not corrected Mr. Kelly's position at all. I have to say I'm quite astounded, actually, that this is Argyll and Bute Council's position in relation to wind farm development, that they will not support wind farm development as a relevant action to combat climate change. That is in effect what Mr. Kelly is saying. Emissions are going up, Mr. Kelly says, but still wind farms will not be supported because there is no impact from them, in his view, on global climate. That's despite the UK being a signatory to the Paris Agreement, which has global objectives. The UK has set out its clear position through UK and Scottish Government policy in terms of renewables. We'll come on to the importance of national development, which this is in NPF4. The Council's position, in my view, cannot be reconciled with the key national planning policy documents which we have before us. I'm dealing with a number of wind farm developments in Argyll and Bute, and I have to say I've never seen this stance. The Council's clearly changed its position, and it's very different to what is written in the report of handling on wind farm development. Thank you.
Thank you. Mr. Kelly, yes.
It's interesting. Mr. Bell has offered you no contrary explanation to mine. He's offered you no evidence on how wind farms in Scotland have a measurable and verifiable effect on global climate patterns.
Mr. Bell has indicated he didn't hear that last answer from. Could you repeat that? Could you repeat that, Mr. Kelly?
Mr. Bell has offered no explanation or evidence as to how building wind farms in Scotland has a measurable and verifiable effect on global climate patterns.
Just before you pop in there, Mr. Bell, we'll come back to that. That's under, I think, 5B. So we can hold that unless there's something pressing that you'd like to say now.
I'm happy to leave it till later, so thank you.
Okay, we'll move on to 3D then. Now, Mr. Kelly, you in particular, you've referred to other policy options and individual actions to tackle the challenges of climate change and help reduce greenhouse gas emissions instead of energy proposals. Is it a question of either or? And what would the application, well, that's for yourself, and then we'll come on to yourself, Mr. Bell, in terms of what the application would bring in terms of greenhouse gas emissions compared to individual actions. So Mr. Kelly first.
I don't think it's quite a question of either or. Looking at the effects of climate change in Scotland, you're looking at effects that were actually first noted in the early 1990s through research by Dr. Andrew Black at Dundee University, who noted changing weather patterns, a slight increase in the total amount of rain, but more stormy days followed by more dry days, great variation in winter snow cover, and also more propensity for floods, river flooding to happen. So climate change is having effects in Scotland. And the view I set out is that really a range of options, policy options, should be investigated and assessed, and priority should be given to those that have the most effect, or the most beneficial effect. And I think looking at the last 2 or 3 years of weather-related events in Scotland, you would probably say river management and flood prevention should be the priorities for actions. So I would be looking for a range of policy options to be developed and assessed, and the ones taken forward should be the ones that are most effective in tackling the effects of climate change in Scotland. Thank you, sir.
Mr. Kelly, just to confirm here, so you're looking at the consequences of the challenges of climate change and a policy reaction to that. Is a wind farm doing something different? Is that looking at reducing emissions in a different way?
You're actually opening up quite a big area there, sir. When you look at emissions, it's maybe again something later in the agenda. When you look at emissions from a wind farm, as I understand matters, the asserted savings, emission savings, do not take account of all the emissions that are generated in all stages of the production of turbines and their transportation to the site. Secondly, you have to start interrogating the practicalities of where the emissions reductions that are claimed are going to come from. Unless Peterhead fires up, which hardly ever happens these days, Scotland has no fossil fuel electricity generation. So in terms of emissions savings through electricity generations, there are no emissions savings to be had in Scotland. There is no fossil fuel energy production in mainland Scotland. So I think, again, back to the point I made before, you're looking at an evidence-based approach being the best one to take.
Okay, thank you, Mr. Kelly. Mr. Bell, do you have any comments?
I think so, yes. I think the first point is Argyll and Bute Council is making an express and direct challenge to government policy at this public inquiry. That's evident through Mr. Kelly's statement in his evidence. Again, I would say that position that's set out cannot be reconciled with the policy documents that are before the inquiry, and that would, in my view, from a planning perspective would be an unreasonable stance to take. I think Mr. Kelly is mixing up climate adaptation and mitigation, and it's certainly not an either-or approach. The policy documents are clear, in my view, from a straight reading of them. And just taking, for example, this development is national development under NPF4. The statement of need is clear and cannot be disputed. For example, it states NPF4, page 103, additional electricity generation from renewables and transmission capacity of scale is fundamental to achieving net zero. Insofar as Mr. Kelly referenced that some emission costs have not been taken into account, that same page refers to the government's life cycle greenhouse gas emissions, that the national developments have been deemed to be net positive in terms of greenhouse gas emission reduction targets. The applicant has set out what the estimated emission savings will be, summarised in my hearing statement on page 30. So national developments have an important, clear role in policy. This is one such development. It's not a case that these can simply be put aside by a council and a council will rely on other actions. Also, whilst fossil fuel generators have largely now gone from Scotland, there is still a need to decarbonise wider society in terms of, in particular, heating in buildings and homes, transportation, and other aspects of the economy in order to attain net zero. Two other references I would make in response in terms of the onshore wind policy statement. Page 49 states deployment of onshore wind is mission critical for meeting our climate targets. And we know that policy 11 of NPF4 is one of encouragement and facilitation for onshore wind subject to assessment. And the council is clearly taking a stance directly contrary to these national planning policy positions. The last point I would make is in the Clean Power Action Plan 2030 that has been lodged, and that's CD 12.026, it does set out that the UK government has a goal of 30 gigawatts of onshore wind by 2030. And at the moment, the UK is only halfway there. And page 10 of that document states that clean power by 2030 is a sprint towards these essential goals. That's energy security, energy supply, and the economic development that goes along with it. So the applicant takes a fundamentally different approach to the council, one that is in step with government policy and not seeking to challenge it. Thank you.
Thank you, Mr. Bell. Just on that final point you made about the Clean Power Action Plan and the UK government, that was 30 gigawatts by 2030, is that right?
It's a range of 27 to 29 gigawatts.
And with it being a UK-based action plan, is there any distribution to the different nations within the UK? Or is it reliant just in Scotland to provide that?
No, there will be some distribution that I don't have. Sorry, fire alarm. Sorry about that interruption. It's all clear now.
Please listen for further instructions.
I'll better just take some instructions here.
Have your attention, please.
Beacon.
Have your attention, please.
Yeah, if you need.
It sounded like a test, but that just then said fire being reported. So if we could just give us two minutes, then that will be very grateful.
Yeah, if you go, you
Yeah.
leave. Yeah.
Yeah.
I think what we'll do while we're waiting to see if they come back is take a 15-minute recess. And when we come back, we can see if they're back in the call. And I'll ask a note to be put up on the screen so that they're back. Okay.
Yes, now happy to report. It seems to me an odd thing to do as part of a test to say that a fire has been reported, please leave. But there you go. It is just a test. We're all right. We're safe.
Okay.
So I apologise for that.
Not at all. Now, Mr. Bell, so I'd asked you about distribution of the 27 to 29 gigawatts throughout the UK.
Yes. There is an expectation that the bulk of that capacity will be in Scotland. There will be some clearly from Wales, some limited in England, but the expectation is Scotland. I don't have immediately to hand the reference to the geography, but can perhaps come back on that.
Thank you. Taking note of that. Mr. Kelly, any further response?
So on the matter of the spatial distribution that you were talking to Mr. Bell about, the UK government has commissioned from Nestle a strategic energy plan, the first iteration of which is expected in 2026. And my understanding is that that will address the geography of both supply and demand. So I would say the first iteration is expected in 2026, and that will answer your geography point at that stage, sir.
Mr. Kelly, if you just explain to me at para 8.13 of your statement, you suggest that electricity transmission from the proposed wind farm could displace production from other operational wind farms. What did you mean by that?
The current capacity to generate electricity in Scotland exceeds the combination of demand, Scottish demand, plus the ability to transmit to England. That's the current position. You also have an additional 4.6 gigawatts of renewable electricity generation capacity under construction and 19.4 gigawatts consented and awaiting construction. So for the foreseeable future, the capacity to generate electricity in Scotland will exceed demand plus the ability to transmit south. And therefore, any new electricity, new generation wishing to come onto the grid would simply displace other generation, resulting in constraints payments. It's a demand versus capacity issue. So.
Thank you. I understand that now. Mr. Bell, do you have any comment on that?
So yes, I think firstly that's these comments are not underpinned by any planning policy, and I would also just question the figure of 19.4 gigawatts that Mr. Kelly has referenced, but there is no policy position that says that there should not be significant weight attached to the benefits of a development because of any change in grid position, whether that's right or wrong in this case.
So can I just advise that the figures I quoted are from the Scottish Government's own energy statistics, published quarterly.
I have added into my table 3 in my hearing statement the BVG report, which lists the different categories of onshore wind development in the planning process, awaiting construction and under construction. And the latest figures I'm showing there under construction is about just a gigawatt, and awaiting construction and consented 6.14 gigawatts. So maybe just a question to Ms. Kelly, is that renewables or is it onshore wind, the 19 gigawatts?
The Scottish Government statistics now lump together offshore and onshore wind when they're talking about the pipeline.
My comment would be that that's interesting but not helpful for this development when we're looking at onshore wind development and the onshore wind target. And I would suggest my figures based on the BVG analysis are the ones that should be looked at in terms of and taken into account for the onshore wind target position. Thank you.
So I actually tend to agree with Mr. Bell on that. I have commented elsewhere that the Scottish Government's changing approach to publishing the quarterly figures is actually not helpful. Previously, they had very clear distinction between onshore and offshore, both in terms of installed capacity and the pipeline. But now, as I said, they lump them together. So I would actually agree with Mr. Bell that the current presentation of Scottish Government statistics is not helpful in this regard.
Okay, thank you. Is there anything else under the agreed statement that parties would like to refer me to? No? Okay. We'll move on to item 4, renewable energy policy and legislative background. Now, I just have a general point here. Are you all in agreement that the documents referred identify a climate emergency? They set emission reduction and greenhouse gas emission reduction targets. They identify that the targets are not yet met and indeed are not a cap, and imply a need for efficient delivery to meet net zero by 2045. Mr. Kelly.
Yes, so they're important considerations. I would simply say that there are many ways to achieve emissions reductions, and it's the targeted emission reductions are yet to be met. It doesn't necessarily mean that wind farms are the only way forward, but I don't disagree with what's set out there.
Mr. Bell, any comment?
So yes, again, I'm just surprised at the council stance. I think the answer is a clear yes, based on the policy documents before us, and wind farms have a clear primary role at the moment, as set out in the onshore wind policy statement that we've referred to earlier. Thank you.
Any further comments from parties in relation to item 4? No? Okay, we'll move on to item 5, the development plan. Now, I take it you both have a copy of the MPF4 and LDP2 in front of you, or you're aware of it? Yes. Okay. So, firstly, Mr. Kelly, in your statement, are you arguing that there would be harm to nature, and I put there birds and habitat displacement, because that's what you've referred to, that would not be outweighed by the beneficial effects to the climate as per policy 1 of MPF4? Sorry, you're muted, Mr. Kelly.
Apologies. You already have my views on climate. I came to that conclusion based on the approach to mitigation and enhancement that was in the application as considered by the council. We now have new material on mitigation and habitat enhancement in a different location. So that conclusion will have to be reviewed by the council. And my understanding is that Mr. Carroll will say something about that at the end of this session.
Okay, Mr. Bell, do you have any comments on that?
So yes, I just comment that what Mr. Kelly said there is not what he sets out in his evidence. The matter of enhancement is different, and that's going to be addressed through the more recent exchange, the Habitat Enhancement Management Plan. But enhancement is very different from mitigation. Mr. Kelly's evidence seems to me to be clear that there's harm to nature and biodiversity such that the development is unacceptable. It seems to be, and that's not a matter that was in the council's reason for objection, but it is in Mr. Kelly's evidence. It seems to me in the reading that impact of harm to nature would not be outweighed by the benefits of the development.
Yes, Mr. Kelly, I'm trying to understand a bit more about, you've been quite specific in saying birds and habitat displacement, which is not subject to the further written submission on the outline habitat management plan directly. So any comment in terms of that?
I had in mind the last consultation response from the RSPB, which you have in front of you, sir. I can't recall the number, but you have a response from the RSPB that discusses these issues.
Okay, so just for my note, it's more you're highlighting to me concerns of other parties, but are those adopted by the council in this case?
I'm not sure what you mean by adopted in a formal sense. Are you expecting the council to somehow, through a committee decision, endorse the position of the RSPB?
Well, it was my understanding from the reasons of objection that effects on birds were not one of the reasons that the council objected to the proposal.
The council were not given professional advice at the time they formed their objection, and therefore what is set out has to be seen in that regard. There is no doubt there is a management issue for the council to address here. Reading the committee report as a whole, the report of handling as a whole, I felt that there were a number of marginal conclusions reached by the case officer, which could easily have gone the other way. And that's why I reviewed certain matters and set out what I did. But as a matter of factual record, the reference to harm to nature is not in the council's reason for refusal, for objection.
So if I may, just to jump in, I'm troubled by this sort of approach from Mr. Kelly. He is the witness who appears to be representing the council, and obviously Mr. Carroll is on the is on the call. There is there are the reasons for objection, it's the report of handling, and all the applicant can do is work on the basis of the responses through due process. What Mr. Kelly appears to be doing now, through very personal views, I have to say, in relation to climate change and wind farms, and now in relation to ecology, is seeking to go behind that in a way that we can't respond to properly. So it's a general observation that all we can do is act on what we are told by the council. There is no objection from Nature Scott, RSPB, or any other consultation in relation to ecology. That's the position that we've come into this hearing session, understanding the council's position to be.
I'm tempted to ask yourself, Mr. O'Carroll, if you have any comments. And obviously we have the author of the report of handling on the call as well. So whether Ms. Gold needs to come into the discussion. But Mr. O'Carroll, any observations?
I think Mr. Hardy's quite correct. I mean, obviously, we indeed stressed this myself yesterday, is that we have a position where we have due notice given the position. The council's position, the objection was made primarily on landscape visual grounds. I think the point that Mr. Kelly is making, though, is that there well, I don't want to speak for Mr. Kelly, but I think I'll just stop there. I think that I fully accept what Mr. Hardy has said and the extent of the council objection. These matters have been raised in Mr. Kelly's hearing statement, and you're asking him questions about them.
I think we just maybe think carefully in the way forward here. Obviously, there's different views. If the view is that the evidence should be limited to addressing the council's reasons for objections, then really much of the rest of the agenda is irrelevant, because it would actually attract the same criticism from Mr. Hardy, that I'm expounding my own views rather than the council's view. I mean, I have a different view of my role, but I accept that there is a case that says that the council can only give evidence based on its reasons for objection. And if you take that view, sir, then obviously it would be open to you to disregard considerable amounts of my hearing statement, and even to disregard my answer to some of these questions. But I think it's a crucial issue, and it's perhaps one we should resolve before we go forward, so we don't waste time on matters.
Well, I think we had this discussion at the pre-examination meeting as well about the terms of engagement, Mr. Kelly. So, you know, what are your terms of engagement, and where are you coming from? Are you what? Yeah, that would be the best way forward for me to understand. How have you been engaged, and how have you approached your involvement in this process?
There were no detailed terms and conditions of engagement. I was asked if I would support the council in objecting to this wind farm. Before replying, I read the committee report. I knew the area reasonably well. I studied some of the environmental information, and I got out my ordnance survey maps and did a careful study of the area. Having regard to all that material, I agreed I could support a case of objecting to this. When I was instructed, I was not instructed on the basis of only the two reasons for objecting. But as I say, I can see the arguments on both sides.
Mr. Hardy, Mr. Carroll, do you have any comments? And then I'll come to a conclusion on how to proceed.
I do. Yes, the council, this is a statutory process. The council has its case, and that is articulated through elected members. I mean, in this case, going against professional officer recommendation, it has to be said. But due process, elected members choose to object to this proposal. They have done that. There are two grounds of objection. It is not acceptable for an independent consultant to come and giving what I would consider to be personal opinions on a whole range of matters, and potentially opening up issues that, ecology and various other things that Mr. Kelly has to, has got to say, for which there is no mandate for objection by the council. There are two reasons for objection. His professional obligations, in my view, are to support the council in those two reasons for objection. There are policy bases for those, and that's what the that is the ambit of the evidence that he should give.
With regard to how we take matters forward, I hear what Mr. Hardy has said, and that's a position that is fully understandable. I think that with regard to what Mr. Kelly has said, then clearly it's a matter for you as decision maker to decide what matters you consider to be relevant to consider the overall balance as they pertain to energy and planning policy. And you've got his answers to that, and it's a matter for you. In terms of moving how we go on from now, we're actually at section 5 of your agenda, which then deals with the development plan, which is entirely germane. And also section 9 is coming out with regard to the 1989 Act, which also is equally germane, and then AbleWex. So I think that I fully I can see certainly where Mr. Hardy's coming from, but I think in terms of proceeding from now, I think your agenda is probably, I hope, will be freer from controversy going on from now.
Okay, I've heard what everybody has to say and understand parties' positions. It's for me just to understand what weight I give to any of the evidence given on that basis. There's only one more question I think here that might be crossing over into, well, straying into other areas, which is B, the next one we're coming on to about verifiable, measurable, beneficial effects. Now, we did touch on that before. Mr. Bell was going to say something about it, so I'd like to keep that question open, and then we'll proceed through the agenda as we have it here. So, Mr. Bell, I'm just going to ask you to respond to that query in terms of 5B. Thank you.
Thanks, sir. I think I've never seen this as a policy test in either an LDP or National Planning Policy. I'm surprised that Argyll and Bute Council is taking the stance that developments have to individually evidence that they have a verifiable and measurable beneficial effect on global climate. As I say, I'm working within the region on other projects, and the council has never advanced that as a requirement for a development. And I've not seen any other planning authority do so in Scotland. So again, I would say that's an unreasonable position for the council to take, not grounded in any policy or guidance that is before the inquiry. And I think that further betrays the position that the council's taking in being reticent about attaching any weight to the benefits of this project. And again, you cannot reconcile that, in my view, with the clear policy position that we've had a look at in NPF4, or indeed in the LDP. I think, in my view, is that the government's clear in certainly NPF4 that it's the cumulative contribution of a number of developments that will help to meet targets. And that is reflected in certainly all the NPF4, post-NPF4 Scottish Government decisions, where the ministers regularly state that the individual development will make a valuable contribution to combating climate change and delivering renewable capacity. And we've covered some of those references earlier. So I think that's all I would say on that point. Thank you.
Mr. Kelly, any comments?
Nothing further to add, sir.
Okay. Could I just ask you, Mr. Kelly, in terms of a global receptor, I mean, if we're looking at the greenhouse gas emission savings, carbon dioxide savings from this project, I mean, if you took the receptors being global, surely it would be de minimis what the effect would be. But from a cumulative point of view, do you have any comment from what Mr. Bell has said?
In the introduction to NPF4 and NPF4 Policy 1 both refer to the global climate emergency. So I would take it from that the Scottish Government would be considering the effects of their policies and proposals on the global climate. That's what it says. My own view, if I'm allowed to express it, is that the correct geographic basis for assessing the effectiveness of policies and proposals on climate change is Scotland. Bearing in mind that this is the Scottish Government with a range of powers specific to Scotland.
Okay, thank you. We'll move on to C then, and that's to do with policy NPF4 policy 4 and LDP policy 71 on local landscape areas. Now, yesterday we discussed this, well, I raised this with the witness slightly. So the first question, Mr. Kelly, policy 4 of NPF4 is not mentioned in the reasons for objection by the council. Is that correct?
That's correct, sir.
And are you aware, Mr. Kelly, is that because the way the wording of the objection is, does that mean that the concern from the council is landscape and visual effects, and that there's no concern to do with the local landscape area? Or does policy 71 encompass that concern with the local landscape area?
You really sought to answer that yesterday in the discussion. In terms of what the council were thinking when they formulated that reason for refusal, I honestly don't know. I can't say. I listened carefully to what Mr. Daly had to say yesterday, and I have nothing to add to that.
If I could just venture an observation, please. Now, what we have is, as we know, is a objection contrary to recommendation. And I don't know if you've had the, if you know the exact process that was undergone by the council when it then issued its objection. But what I think you will know yourself, sir, that this is done in a very much more kind of less considered fashion than one might find in relation to the planning officer compiling the report to committee. And obviously you ended up with 2 paragraphs setting out objection, which is done on the same day as the committee decision, as opposed to something that's been considered in advance by a planning officer sitting in their own the environments of their own office. So clearly it's going to be, it's quite likely to have a certain less than polished than you might otherwise hope. So what I suggest perhaps as a pragmatic approach would be to at least allow a certain amount of latitude taken into account those particular circumstances. So you have a disparity. On the one hand, there is reference made to policy 71 of LDP2, which is a policy entirely dedicated to local landscape areas. But you have an omission in the policy 4 of NPF4 has not been mentioned. Clearly, thinking in a considered fashion, setting them down, that the LLA is covered by both policies, and that clearly should have been done. And the absence of that is an oversight, but I think an understandable oversight. And think about things more widely as well. Is what the council's done is they've been required to also not only have an independent planning witness, but also they've had to then go further afield and obtain another planning landscape and visual impact assessor, landscape and visual architect witness as well, who also has then provided an independent view. Now, the applicant is fully engaged with the question of the aspects of local landscape areas. There was considerable amount of evidence in chief from Rebecca Rylott looking at special landscape qualities, which I'll be submitting on later. So this is a matter that clearly is before the inquiry. So what I would just venture to suggest is that the absence of policy 4 shouldn't mean, for example, that the extreme position could be taken that in my closing submissions, I'm some way debarred from mentioning policy 4 of NPF 4 because it wasn't mentioned in the reasons for objection. I think that would lead to an over strict interpretation and an absurd result, because these were matters simply clearly of evidence, and they're matters for you, and they're matters that matter in the round in terms of the overall planning balance. So yes, no policy 4 mentioned in the reasons for objection, but clearly it's before the inquiry. That's my observation on that. Thank you.
Yes, thank you. No, I don't think I was asking a question if we shouldn't consider policy 4. It's more an observation that it's not in the reasons for objection. I can understand some amount of latitude, but from my experience, I would have thought there'd be lawyers and committee clerks and the planning officer themselves at that committee could have helped the councillors come up with a competent reason for objection. I think my concern, if we look at those two policies, and obviously LDP2 was adopted after NPF 4, and so if there's any conflict between those policies, the latter will take precedent, which in this case would be policy 71, and that's the one cited in the reasons for objection, not NPF 4 policy 4. And that's the reason I'm asking this question, is to try and understand, is there a nuance between these two policies that mean that one was referred to and the other wasn't? Mr. Kelly, are you aware of any nuance between the two? Obviously, policy 4 of NPF 4 refers to integrity. Policy 71 of the LDP doesn't appear to do so. Mr. Kelly.
Not aware of any nuance as such. My interpretation of what happened is simply that it was an oversight not to cross-reference policy, NPF policy 4, in the reason for objection. I don't think there was any subtlety or any detailed discussion around that point. It was just an oversight.
Mr. Bell, I think you're probably reading those policies, looking at your lips, but any comment?
If I may just make the first comments. I mean, it's been a very interesting morning generally, and I find that what the councillor said really quite extraordinary. The statutory process is there to articulate the council's reasons for objection. What it has done, and it isn't it's not unclear in the wording of the two limbs of the objection what the council is saying. And the most important point is that it is entirely consistent in terms of finding significant adverse effect on both landscape character and indeed on some parts of the special qualities, with the expert consultation response from Carol Anderson. So in her report, which is very detailed, it sets out those things which we've gone through in the L&V section. But as you know, she says in terms and advisedly that does not impact on integrity. And that's what happens with the planning officer as well, synthesizing all of that. They take the view that, yes, there are significant adverse effects on character and visual amenity, but they don't go to integrity. So it is entirely consistent with that members took a different view about character and amenity, so they went the other side of the line and they wanted to object on that. So I simply cannot accept that it is an oversight that national policy, in the form of policy 4, was missed out by mistake. What has happened is an elaboration of the case, and without mandate, the L&V case that was run by Mr. Daly, as I've put, and it will certainly come back in closing submissions. He's gone off on what lawyers might call a frolic of his own, and that is without mandate from members. So is it something you have to consider? Yes. And then to Mr. O'Carroll's point, well, look, we spent time at the inquiry session dealing. Yes, we did, because that's the case that we have to meet. It would have been a very bold statement to say we are not putting in any evidence to meet the case that the council is now putting. That doesn't take away from the fact that it is without mandate. So I simply do not accept the explanation given by the council.
Thank you. Mr. Bell, any comment on the two policies?
Nothing further, I don't think, sir, beyond what I've got in my evidence, unless you've got any additional specific questions on the policies.
Well, let's hop back to the first part of the question under C then. So would the proposal provide any social, economic or environmental benefits of community-wide importance? Mr. Bell.
Well, yes. Looking at that first point, yes, the applicant's position would be that the development is of national importance because of its national development status, and therefore far above the benefits of at least local importance in the second limb of the policy.
Mr. Kelly, do you have any observations on policy 71 or policy 4 of MPF 4?
No, I've nothing further to say on this matter, sir.
Okay, thank you. In that case, we'll move on to MPF 4 policy 11. Do all of you accept that significant landscape and visual effects are expected? And do you all agree that the term localized refers to a geographical extent? Mr. Kelly first.
Yes, sir. I think it's a statement of the obvious that for wind farms, landscape and visual effects are to be expected. But you also have to, and yes, I agree that the term localized refers to geographical extent, but you also have to take into account the sensitivity of receptors. My concern with this policy is the additional wording that localized effects are likely to be acceptable. I find it hard to understand how you can make such a generic statement, which I accept is made, without understanding the specifics of a case in a specific location. But hark back to your questions, yes, the effects are to be expected, and yes, localised refer to geographic extent.
I wonder if I could just chime in with that, please. Mr. Kelly said, yes, it's geographical. Obviously, that's what the word means in common parlance. But he also referred to taking into account the sensitivity of receptors. And I think that's also correct, I think, just on any common sense view. There are significant landscape effects to be considered, but if you imagine, though, that if you just simply took geographical distance as being the only thing, that it might be that 10-kilometer distance between the receptor and the turbines involved would be bad in one case and then bad throughout. Well, clearly that can't be the case, because the undulating of the nature of patterns of landscape terrain between the receptor and the development obviously is clearly very important, and indeed the main subject of the landscape and visual evidence that we heard. So it's all qualitatively different. There is, if you had a completely flat plane between the receptor and the development, then that would be quite different for one that is then has other undulating landscape matters. So you have to do, as Mr. Kelly says, you have to do more than consider that particular distance and purely bald terms of the number of kilometers between the development and the receptor. This is, I know it's not an actual core document that's lodged, but it's one that I think you'll be very familiar with. And I think it puts matters a lot better than I did just now. And that is the four-side decision, whereby the reporter in that case said, I found the applicant's main use of distance to determine localized impacts to be too simplistic, and I consider the more fine-grained approach is more appropriate if such impacts are to be properly understood in the local context. And I think that's really, I don't think I can improve on that. I think it's a fine grain considering the actual local context, and it's not just distance alone.
Thank you, Mr. Carroll. Could you just give me the WIN reference for that decision?
Yeah, and again, I do apologise the fact that it's not being included in the documents. It's WIN-130 of 2007.
Thank you. Now, Any further comments in terms of significant effects in the term localised?
Yes, do you want me to come in on that now?
Yes, Mr. Bell, if you have any
Yes.
comments.
Just to say, my answer is yes, that they are to be expected, and NPF 4 policy 11 paragraph E tells us that. And the wording on localised is very clear. Where impacts are localised and or appropriate design mitigation, then they would generally be considered to be acceptable, and that's a geographical spatial extent point. But yes, there are, of course, other considerations that may come into play. But on that point about localised, it is spatial extent, in my view.
What we're going to do, there's still a few items here, but I think we can probably get through them unless anybody would like a break just now.
I would, please, sir.
You would. Okay. Well,
5 minutes would be sufficient.
Yeah, let's come back at 11:10 and we'll finish the last of the agenda.
Thank you.
Thank you. There again, we can open up our cameras, please. Thank you. So moving on to the agenda, 5E, we're looking at MPF4 Policy 11, Criterion C. So Mr. Bell, is there a demonstration that the net economic benefit will be maximised?
Excellent. Yes, there is, in my view. I think this aspect of NPF4 Policy 11 has been an issue at large for some time, given there was no guidance on it. And I think the way forward on it is to look at the benefits that would arise from the development. They're reported in the EIA report in Chapter 7 in terms of socioeconomics. And I've summarised them on page 31 of my hearing statement. And there is reference to the gross value added from the development, the employment effects of the investment during construction, in particular, where that typically is where the majority of the benefits would be. And then there is also the applicant's commitment to maximise local supply chain content. When you look at all of the post-NPF4 onshore wind decisions that the Scottish ministers have issued, in all cases, they have taken the position that the reporting of those effects mean that aspect of Policy 11 is satisfied. So in my view, this project has demonstrated maximisation, and the council's not raised any additional matter that the applicant is falling short of in terms of that aspect of the project. Thank you.
Sorry, in terms of local contractors, you mentioned that a commitment. I mean, a commitment's obviously not binding. It's an aspiration to do that. Are there any local contractors that you're aware of that you would use in this case?
I mean, possibly McFadden's Haulage is a local contractor in Campbelltown, very close. Now, clearly, pre-consent, there are no commitments to individual contractors, and there has to be a due process followed. But the applicant's well aware of the contractor position, and I think a number of years ago the towers were manufactured just a few miles away at Machrihanish. Unfortunately, that has fallen away now. But I think, given the geography of Argyll and Bute and the presence of quite a number of wind farms, there is already within the region an awareness amongst and a capacity within the contracting sector. McFadden's being well known nationally, for example, and the grid infrastructure that has also been upgraded, and there's an ongoing programme of that, all the way from the northeast at Dalmally right down through the entire peninsula. And you've probably maybe seen that on your site visits, where there's been a lot of contractor activity. I think there's good prospects based on all of that for the applicant here to make known the project in due course and to get a reasonable and good representation from local contractors. But that's typically done with effort post-consent when there's certainty, and then contractors can come to events like Meet the Contractor event, maybe in a hotel in Campbelltown or something, or Machrihanish, actions like that.
Thank you. Now, I'll ask you to come and comment on that, Mr. Kelly, but also you've talked about social and environmental costs and displacement from the wind farm as proposed. If you could describe that to me as well, thank you.
I know what Mr. Bell said. There's an issue around the wording of the policy, and some of your colleagues in other cases have looked for evidence that goes beyond an economic impact analysis and looking for specific measures to demonstrate that the economic benefit is maximised. So I have no adverse comment on what Mr. Bell has said and the intentions of the applicant, but I'm not convinced that demonstrates that the benefit has been maximised. In relation to the second half, this is just standard economic impact assessment stuff. When you carry out an economic impact assessment, you look at costing the externalities, and you look at whether there would be displacement from the local economy. So there's no specific criticism as such for this applicant. It's a general statement that these are matters that should be addressed when considering economic impact assessment, externalities and displacement, and it's a standard technique, sir.
Okay, and you're saying in that case, if there's an omission of that, then there isn't a proven maximization of economic benefit?
It's difficult to give you a precise answer because I agree with the position as stated by Mr. Bell. We are in a situation where we don't have any guidance on how this is to be applied. So we are rather feeling our way in dark. The Highland Council has, for example, is looking to develop a charter that it is looking for wind farm applicants and companies to sign up to in terms of delivering certain benefits in certain areas, although the wind industry, I think, is rather resistant to that. There's probably not much more I can say, sir. The policy says maximise the benefit, but as Mr. Bell says, we have no guidance on how to assess that.
Yes, Mr. Bell, this is going to come to you. Yes, thank you.
Thank you, sir. I would say I'm grateful to Mr. Kelly for what he said about the general position on the policy, but in Mr. Kelly's evidence, he takes the position. Well, the council takes the position that there's conflict with Policy 11 because of the matter has not been maximised. Now that's, I would say, counter, as I say, to all of the Scottish Minister's decisions on this. So it's paragraph 16 of Mr. Kelly's evidence that the proposal conflicts with Policy 11 because of the lack of accordance with this aspect of the policy. Again, I would say it's the first time I've seen Argyll and Bute Council take this stance. They didn't do it on An Cardew recent scheme or Ladyfield, a recent scheme they did not object to. So I'm surprised to see this stance taken.
Right, and Mr. Bell, what about costs and displacement? Has that been considered at all in the EIA? Well,
I would just put it with respect back to Mr. Kelly. I mean, what displacement is alleged here that this development would do? I mean, it's not like it's a retail development that would displace other activity. What is the displacement concern that the council has? I struggle with understanding that. Thank you.
Right, Mr. Kelly, any comments on that? Thank you.
No, sir, nothing else really to add. You would actually have to carry out the study to assess whether there is displacement or not. Look at the various costs. It's a general approach to economic impact assessment. So nothing more to add, sir.
Thank you. Okay, we'll move on to F. Mr. Kelly, you mentioned within your statement, paragraph 17.
I'm sorry, sir.
Yes, Mr. Carroll.
Sorry, I'm sorry to interrupt. I was actually speaking, but I realised that classically I was on mute. I wonder if I could just add a little bit onto what's been said by Mr. Kelly. He said that the EIA has had subject to a standard economic analysis, and I think that's correct. That in any event, at all times, as Mr. Bell has pointed out, the way you have a new wind farm development, there will be economic activity, which is of benefit to the area. That's to be expected, just as one can expect landscape and visual impacts. The question is, as Mr. Kelly has correctly emphasised, is one of maximisation. And I would suggest that another way of looking at it might be that since it's something to be expected and there's nothing been additional that's been described that perhaps at the best it could be, the economic benefit could be described as neutral in the overall planning balance. The other thing I wanted to just venture was with regard to displacement, and I might be slightly out of context here, but I think it's helpful in the overall consideration of matters that we have, as I've often commented upon in previous inquiries of this nature, that we have an inherent paradox in every wind farm case where it's been objected to, because the clear aim in having renewable energy is to benefit the environment and to do things that can be said to combat climate change, whether locally or globally or either of those. But then the environment is a wide concept that encompasses the local environment, and that encompasses, of course, visual and landscape impacts. So if we're talking about displacement, I think we have the classic tension here between what is said to be of benefit to the environment in terms of global greenhouse gases emissions, but also the tension, obviously, is the other environmental impact, and that's going back to policy one, I suppose, the one to nature and the landscape and visual impacts that will be experienced by others. So it might not be entirely within the four corners of what you're saying there, but you did say it was iterative, and I do think there is that paradox and that tension between those aspects of the environment. I think are matters worth raising, and you also have my submission with regard to the neutrality of the maximising of economic impacts.
Mr. Bell, do you have any comments in terms of particularly that term neutral?
Yes, I would not accept that at all. That there's a neutral impact. It's clearly a net beneficial impact. I fully accept it's a fair point that the issue of maximisation remains, debatable. It's a matter that some reporters grappled with when it first came out, and as Mr. Kelly clearly said, but when you look at all the Scottish ministers' decisions, they rely on the position as conventionally reported in an EIA report, which is net additional activity. It would not happen elsewhere from this project. It has to be this project. There will be others coming forward, clearly. And I think what I would also refer you to is one document. Now, it's one that the Council does not agree to, as we started off this discussion. It's the Green Industrial Strategy for Scotland that was published in September last year. It's CD 12.017. Now, I don't think we need to go to it. It's referenced in my hearing statement on pages 27 and 28. But the actions coming out of that include exploring circularity opportunity in onshore wind in Scotland. And at my paragraph 2.8.6, I've pulled out the quotation from the Green Industrial Strategy, where it refers to onshore wind as the biggest single technology in Scotland's current mix of renewables. And the fourth or fifth paragraph I've referred to there, it talks about onshore wind workforce being highly skilled, opportunities in installation, consulting operations and maintenance are anticipated to rise in response to growth ambitions. And it goes on to say there is commercial opportunity in circular supply chains related to the UK wind industry. So we talked about earlier, Macrahanish is gone now, but clearly with economies of scale, that supply chain is going to be further stimulated with more development coming forward. And that's what comes through in NPF4 National Development Statement as well. So I'll leave it there, but I would say that there is very strong policy support for that wider supply chain opportunity that the government clearly aspires to in terms of economic growth as well. And it will be the collective contribution of individual projects that will enable that objective to be achieved. Thank you.
I suppose the remaining question is what more could be done to maximise the economic benefit? Is there anything yourself, Mr. Kelly, that you could highlight hasn't been done?
Mr. Bell, let's refer to the fact that he's at the proposals at the pre-consent stage, so there's a limit to what they can do. Other things I've seen include supplier training programs, secured apprenticeships, funded apprenticeships. There's a range of measures which will be specific to the specific proposal and the geography of the area where that is located. But I do accept what Mr. Bell says, that there's maybe a limit to what can be done at the pre-consent stage in terms of giving commitments to people.
Thank you. Any final comments in this particular matter?
Thank you, sir.
No, thank you.
Okay, move on to F. Now, Mr. Kelly, paragraph 17 of your statement, you imply that there are failures in the proposal in inadequately addressing impacts on communities, local roads, and biodiversity. Is there anything you'd like to say on that matter?
Referring back to our earlier discussion, that was my assessment based on a review of all of the material before me. It's not in the council's reasons for refusal, so I think best I say nothing more than beyond what was in my evidence.
Any further comments on that matter? Mr. Bell?
No, sir. I think we've given our position on all the other matters non-LVIA, which we consider to be acceptable, supported by the consultee positions. Thank you.
Okay. So finally, on this topic, is there any suggestion for community ownership in this case?
No, sir. That is not one of the benefits. There is community benefit in line with Scottish Government guidance, but it's not a scheme that has community ownership.
Thank you. Now, considering the development plan, are there any other comments that anybody would like to make? No. Mr. Bell?
No, sir. Thank you.
Okay, so I think we can take the rest of these fairly shortly, but other matters. So this arises just from a comment that Mr. Kelly made in his statement. So in terms of Schedule 9, and I think you've confirmed this in your hearing statement, Mr. Bell, the applicant is not a license holder. And therefore, sections 3(1)(a) and (b) of the Electricity Act 1989 wouldn't apply to them. Is that correct?
Yes, that is the position. However, this is normal practice. An environmental impact assessment has been prepared that looks at the likely significant effects, and the applicant has had full regard to the matters set out in the Act that you've referred to in those sections, and also has done what it reasonably can in terms of mitigation on these matters as well. Thank you.
Sir, if I could just jump in there, please. Mr. Bell has given his statement with regard to what's within his hearing statement. In terms of Schedule 9, that his statement is at 1.3.4, which he's referred to just a moment ago. And that's where he says the applicant does not hold a generation license or exemption under the 1989 Act. As we know from the NLEI case, that nonetheless there is information which the ministers can take on board, which are presented anyway. However, there is, appears to me, a discrepancy in the positions taken, which I'd like to be ironed out now. I think it might be helpful for you, sir, if it were ironed out, because if we look at the SOAM dealing with policy and go to paragraph 7.3, this is a matter I think that should be clarified. 7.3 in relation to this topic says subparagraphs 3(1)(a) and 3(1)(b) apply to the applicant as a license holder and require license holders to do when the matters are set out. So we've clearly got contradictory positions, as far as I read them, as between what's stated in the agreed matters and what's stated by Mr. Bell in evidence today. I would just simply like to know, are they a licence holder or are they not?
Yes, I can respond quickly on that. That's a drafting error. It should be the other way around.
So what's the other way
Our
around?
apologies for that.
What would be phrased? Which part of what would be phrased and what would it say? My question, sorry to take over, sir.
Well, it would be, as I've summarised, that the applicant does not hold a generation licence and therefore the statutory duties set out in paragraph 3 of Schedule 9 to the 1989 Act would not apply, but they would clearly apply to the Scottish ministers in making a decision. And the comments that I made earlier would still stand, that notwithstanding that position of not being a licence holder, the applicant has had regard to those matters through the preparation of the EIA and indeed in terms of mitigation.
So I wonder, sir, if we could take a fairly unusual step of just simply striking out 7.3 of the Statement of Agreed Matters.
Well, I mean, that's an option. The other option is just to take it that you would insert the words "do not." So subparagraphs 3.1a and 3.1b do not apply to the applicant. Mr. Hardy.
Yes, well, the alternative is that we just do insert some text which is accurate. I mean, it's not, it just needs to be right. We do that over lunch. It's not going to take very long, and we come back and report that for the condition session. I think I'd feel happier with some agreed text.
Yeah, I'm agreeable to that, Mr. O'Carroll.
Yes, thank you.
Yeah, okay, we'll do that. Thank you, Mr. Hardy. Okay, moving on to the agenda. In terms of the other documentation that's been referred to during the course of the inquiry, so the LWEX, there's a technical note on renewable energy and the landscape capacity study. What weight for decision making should I give to those documents? Mr. Bell.
Thanks, sir. I think in terms of the LWEX capacity study, I think it's outdated to the extent that it doesn't deal with turbines over 150 metres. But it is a very helpful document in terms of its sensitivity appraisal, and I think Ms. Rylett's looked at it from that perspective as she set out in her evidence. It has also been prepared by, as we know, a hugely experienced landscape architect that's been advising council for a number of years. We do have, of course, a more detailed LVIA, to which more weight should be attributed. These studies are always very helpful starting points. In this case, I would say it's moderate weight to that document. In terms of TN12, I've had real trouble sourcing that, and I didn't see it referenced on the report of handling, and likewise with the wider non-wind capacity study. So I'm struggling to give you a view on particular weight to those latter two documents. I think if that general landscape capacity study is available, because it's a general one, it's probably limited weight to that. But as I say, more weight to the LWEX, given it's specific to the land use type that we're dealing with in the application.
Thank you, Mr. Bell. Yes, those two documents that you were struggling to find are referenced on page 56 of the LDP2. One has a hyperlink, the capacity study. The other is blank, so whether that's available or an older document, I'm not sure. But Mr. Kelly, any comments on the weight to be given to those documents?
I would endorse what Mr. Bell said in terms of the helpfulness of the landscape and the wind energy capacity study is a helpful document. Like him, I couldn't find the other two documents. In terms of weight, I think that's a matter for submissions from Mr. Carroll in due course. But I would confine myself to agreeing with Mr. Bell that this capacity study was a helpful document.
Well, it is a matter of submission, but spoiler alert, it will be my submission that the capacity study should be accorded significant weight. And as will be clear from the questions I had for Ms. Rylott, with which she agreed, is that the landscape of the area in question that we're dealing with has not changed in any meaningful way, and that therefore the conclusions of it in relation to that specific area are still valid. And that the other thing, of course, to be borne in mind is the new terminology, and that for where we will references made in LWEX to capacity, that should probably now be read as terms of adjudged sensitivity. But I say that as Mr. Kelly has pointed out, that'll be a matter of submission for me later. But since you're asking, that's the weight I think should be applied to it now. Thank you.
Mr. Bell, yes.
Sorry,
Well, I can't hear you for some reason, Mr. Bell. There we go. No.
can you hear me now?
Yes, thank you.
Oh, sorry, I'd inadvertently pressed mute on this. I was just making the point that I have to just respond to that and say that Mr. Kelly, as a Chartered Town Planner, is giving evidence for the councils and agreed with my position on weight. Totally different to what Mr. Carroll is just saying that the council's position will be. Now, I just wanted to flag that point. I think it's important. Moderate weight was Mr. Kelly's evidence. Thank you.
Sorry, Mr. Kelly, are you coming back in? Yep.
To reflect, remember what I said. I don't think I commented on weight. I agreed with Mr. Bell that it was a helpful document. I don't recall saying anything on the weight to be given to it. I deferred to Mr. Carroll on that. Apologies if I have said otherwise, but my comment is limited to the helpfulness of the document, which I agreed.
Okay, thank you. I mean, I have a note of it. I could also review this recording if required, but thank you. Now, I think you've already covered this briefly, Mr. Bell, but LWEX, is it still relevant in relation to the change of design of wind turbines that are available? So in terms of hub tip heights and the swept paths off those devices?
Sensitivity.
Yeah, sir. I think, as I said earlier, in terms of the sensitivity references, it's helpful because that has not changed. The landscape has not changed, as has been said. But just to reference the onshore wind policy statement, paragraph 3.6.1, it says meeting ambition of a minimum installed capacity of 20 gigawatts of onshore wind in Scotland by 2030 will require taller and more efficient turbines. Then it's got underlined, this will change the landscape. So that's in the context of NPF4 as well. So the policy position has clearly moved on, and government has signalled to decision makers that, look, turbines will get taller, and around the country we have seen landscape capacity studies be updated. The name capacity is gone. For example, Dumfries and Galloway has brought out a new one that now refers to different turbine typologies, and we can expect that. So this one is behind the time, so it's dated in that respect, and that needs to be taken into account. But aspects of it are clearly very, very helpful still today. Thank you.
Mr. Kelly, any comments?
No, sir, nothing further to add to what Mr. Bell has said. It remains helpful, but you have to recognise that technology is changing in line with policy requirements.
Okay, Mr. Carroll, sorry, you looked interested for a minute.
I'm always interested, sir, in everything that's been said. Now, again, harking back to my cross of Miss Rylett, it's true the technology has changed and turbines are taller and more efficient, but the landscape and visual impacts that are caused have also changed, and the landscape has not. Those are the simple points I've already made.
Okay, and then just very briefly, Mr. Bell, just confirm in your hearing statement, you appear to refer to provisions from Defeat and Galloway Council. Is that was just cropped up in error? Is that right?
I am partly my fault. I'm guilty. It was an error. So those two paragraphs can be struck out, and my apologies for any confusion that arises. Thank you.
Just for my purposes, was there a substitute that should have gone in there, or?
No, I referred to it earlier, and I was aware Ms. Rylett was going to be covering it, so I referred to it earlier in the landscape and visual section of my evidence. Under NCAT 4 Policy 11. Thanks.
Thank you. Now, are there any other relevant matters to do with planning or energy policy that parties would like to raise?
There is one matter I'd like to raise, sir, and I think at the end it might not be, I'm not sure if it's going to make all that much of a difference. It's really by way of information, I think, to the inquiry. Now, we've referred to in the course of the inquiry so far, on many occasions now, document 605, which was the reasons for objection, and then appended to that you have not only the report to committee, but also an incorrectly dated update to that, which is for some reason a year out. I can't quite work out why, but it's clearly an adjunct to the 29th of May decision. And that anticipated, or at least stated a hope, if I could put it that way, that there would be an opportunity for 80 hectares of compensatory biodiversity enhancement measures at Lajiban Nature Reserve. Now, we know that matters have changed since then, and that there will be no off-site biodiversity enhancement, and it will be on-site. Further to that, there has been the OHMP has been produced, one in October and one in November of 2024. The November one is at core document 16019. Now, the only thing I wanted to say about all of that is that those are, as you said, day one of the inquiry, sir, those are subject to consultation responses that are due on the 3rd of February. And by way of that additional information which has been consulted upon and advertised. And certainly you can expect that there may well be a consultation response from Nature Scott and others, perhaps RSPB or others prior to that date. An internal matter for the council is that given that it's a consultee, we're required to report on that also to the committee in light of those responses received by those other statutory consultees, so that the final position of the council will only be known when that internal process has been undergone. Will be after a committee meeting on the 19th of February will be the next one, or potentially after, more likely would be after that on the 19th of March. So what it really boils down to is that given that internal process, and given that the OHMP will be subject to statutory consultation and responses to this inquiry by the 3rd of February, that clearly is not going to be something that the council will be able to take on board and provide you with a finalised position in respect of it. Having said that, I can indicate that I've been instructed that the council's position is likely to rely heavily on what has been stated by Nature Scott in that regard, and will follow that. It's the most likely outcome. So that finally then is the reason why I state that is because in light of the dates in question and the timetable that we're looking at, that it seems that it's ultimately, despite the earlier hopes of the wider biodiversity enhancement, you have now what the applicant's position is in that regard, and that's something that you will have to have regard to when you consider the overall planning balance in relation to those other matters which you'll take on board. And that's the position as it will be. That's so. I just simply want to make you aware of the internal situation, but that it seems highly likely and seems inevitable that what you'll need to do is to go forward and make a consideration of that biodiversity enhancement in relation to the OHMP as part of your decision in the balance, without knowing the council's finalised response after being considered by the committee following consultation responses probably after the 19th of March.
Okay, so just draw back a minute, Mr. O'Carroll. Thank you for that information. So I think on day one, we said that the additional information responses were due by the 3rd of February. I've only to date received one, possibly two, from members of the public in response to that. I don't have any statutory consultee responses as yet. I thought we agreed on day one that there would be I would allow a 14-day period, basically to do with further written submission on ecology for the council to reply. Now that would take us to the 17th of February, 2 days before that 19th of February committee meeting. So there would be a long lead-in time to that committee. I don't know when documents need to be submitted to the committee, but I could see there'd be potential to go to that committee. If indeed it had to go to the 19th of March, well, that's only 9 days after the closing submission for the applicant. So it wouldn't delay my inquiry report to know what the council thinks. I just wonder, in this case, there's no scheme of delegation that the committee members can delegate to yourself, Mr. O'Carroll, on their behalf to respond along with your team?
Well, no, there isn't. But also, even within that, I was careful to phrase this as being additional information has been given to me to convey to the inquiry, because not only is there no scheme of delegation for me to undertake that, but then I can see Mr. Hardy's at the ready to point out once again that the reasons for objection didn't include anything to do with biodiversity enhancement. That was, as I said before, something that was stated as being a potential benefit from the scheme. So in terms of my involvement with that, I think I can't professionally speaking do anything with that myself, providing any further submissions to the inquiry. I simply wanted, and I think you've very helpfully then considered those particular matters, but I just wanted to lay out the way things are and to consider what you wanted to do, or indeed the consequences if nothing could be done.
Okay, and further, just to clarify, if you weren't able to give a response, you're happy to default to nature, Scott?
Yes, essentially that's what it boils down to, sir, yes.
Mr. Hardy, any comment?
Yeah, well, a couple of observations. Really, my principal one is I'm not sure why that needs to go back to committee at all. It isn't clear to me. If it is going to go back to committee, I think the indication has been given that the council is very likely to follow Nature Scott, and our understanding is that Nature Scott are content, so that should be something which is positive. All I would be keen to ensure is that there isn't and I thought that when the point was initially being made, that the council was seeking an opportunity to kind of finalise its overall position and perhaps shore up some of the points that have been discussed in the inquiry this week. That clearly wouldn't be acceptable, and I would have something clear to say about it. So the overall point is we're not sure why it justifies going back at all. If you're happy or the council insist on that, then the timescales I think that you just outlined work, and we'd be happy to abide by them.
Sorry, Mr. O'Carroll, so there's just one outstanding question there about why it needs to go back to committee.
Could I ask Mr. Kelly to answer that question?
My understanding is that it goes back to committee because it's new environmental information, is additional information. Capital A, capital I, and you ruled that, sir, and it's going through a statutory process, and that statutory process involves officers reporting to committee. As I understand, my understanding is the same as Mr. Carroll's. There's no scheme of delegation that would apply to this.
In any event, though, I think what it would ultimately amount to would be that you'd be provided with that further final information once it becomes available at the end of that. But I've already indicated the likely tenor of that information.
I mean, I hear that, sir. Just to jump in, I'm really puzzled. It's not the sort of matter that, in my view or experience, would need to go back to committee. I don't know if there was a provision that the council was relying on to suggest that somehow there was a legal obligation, and it might be. I mean, whether they can provide that, over the lunch break, it would be good to see. Doesn't feel like it to me.
I'm just trying to figure this through in my mind. The council, are they not a statutory consultee for the environmental information? So
yes,
so they'd be entitled to give a response by the 3rd of February.
Yep.
To that. So I'm just trying to understand why would it be the response, Mr. O'Carroll, by the 3rd of February that needs to go through the committee?
Mr. Kelly.
The normal process, as I understand it, is that the council's case officer would take advice from her colleagues. She would review the statutory consultee responses from the other statutory consultees and prepare a comprehensive report to the committee that addressed both the internal consultation replies and the external consultation replies in relation to the additional information. Reporting, in my experience, reporting important additional information to the committee is not unusual.
Great. I think what I have before me is a range of dates, and I'm going to have to go back and review the EIA regulations myself to see when and who and where people should be responding at what time. So I'll reflect on that and come back to parties. What we have agreed is that the AI responses are due by the 3rd of February, and that parties will be given an opportunity to respond to any comments that were received. And what I'm hearing is the council wouldn't be able to do that until at least, well, possibly the 19th of February, but maybe the 19th of March. So I'll have to take that into account, and I'll come back to parties on how to proceed. Any further comment on that? No. Mr. O'Carroll, I think you're frozen, so. You still there? Yeah.
I am
Okay.
there.
Well, if there's no further matters to be raised, then thank you all for your participation today at this hearing session. We'll reconvene at 2 o'clock for the conditions hearing session, and I'll see you all then. Thank you.
Thank you very much.